Hello and welcome. Today, we're diving into one of the most intellectually fascinating and commercially volatile battlegrounds in modern equity, the constructive trust. Imagine entering into a property transaction, a corporate arrangement, or a domestic partnership. You have a specific set of intentions. Years later, a dispute arises and a judge looks at your case and declares, even though you had never intended to create a trust, equity dictates that you hold this property for the benefit of another. In the case of Carl Z. Stiftung and Herbert Smith, there's no all-embracing definition of constructive trust. However, from the case of Paragon Finance, it operates entirely by the operation of law. It's a mechanism completely independent of and often contrary to the actual subjective intentions of the parties involved. So, our question today is, are the courts being fair when they do this? When judges engineer a proprietary interest out of thin air to achieve justice, are they acting as a court of conscience or are they destabilizing the very foundation of property law and commercial certainty? So today, we'll evaluate this fairness across categories of constructive trust. To first evaluate fairness, we must first understand the global legal landscape that is deeply divided on what a constructive trust actually is. The law struggles with a fundamental conceptual choice between institutional trust and remedial trust. So, in jurisdictions like the UK, the constructive trust is treated as an institutional trust. As affirmed in the case of Westdeuce Lands Bank and Islington LBC, it recognizes a proprietary interest that is deemed to have already arisen in the past due to all unconscionable conduct. To make this fit within rigid property laws, the court often has to look for a common intention. In countries like Canada, New Zealand, and increasingly in Malaysia, the courts have leaned heavily towards the remedial constructive trust. Here, the court looks at a situation of unjust enrichment or unconscionability and finds it unfair and applies the trust as a surgical prospective remedy to transfer the property rights. The problem with the institutional trust is that when there is no actual intention, the courts must rely on legal fictions to invent it. The problem with remedial trust is that it gives us the judges massive discretion to rewrite property rights based on their own perception of fairness and heavily compromising predictability. Now, let's analyze how these tensions manifest across different legal situations. Now, let us begin with situations where the courts impose a constructive trust to strip away profits from unlawful acts or unauthorized fiduciary gains. In these scenarios, the parties absolutely never intended to create a trust, yet the courts aggressively enforce one. Is this fair? In the landmark case of FHR European Ventures and Cheddar Capital Partners, an agent took a secret commission. The court ruled that the agent held this bribe on constructive trust for their principal. Next, in the case of in the estate of Crippen, a husband who murdered his wife was legally barred from inheriting her estate under intestacy. The court imposed a constructive trust over the assets for her alternative beneficiaries. In the case of Industrial Development Consultants and Cooley, a managing director feigned an illness to resign and personally take a lucrative contract that belonged to his company. He was held to hold all personal benefits on constructive trust. So, in these contexts, the court imposed trusts are universally praised as fair. Why? Because equity acts as a court of conscience. The trust here is more than a legal catchphrase, it is a strict moral imperative to ensure that a wrongdoer does not profit from their own unconscionable conduct or breach of faith. The complete absence of an intention to create a trust is irrelevant because the primary focus of fairness here is restitution and deterrence. Now, moving into dealings with land, we see that the courts imposing trusts where a party attempts to rely on strict legal formalities to perpetuate a fraud. In the case of Bannister and Bannister, a woman sold a property to her brother-in-law below market value based on an oral agreement that she could live there rent-free for life. Then, he later tried to evict her, arguing that the agreement wasn't in writing. The court stepped in, using a constructive trust to force him to honor the life interests. Similarly, in the case of Palin and Morgan, two competing parties agreed at an auction that one would refrain from bidding and the winning party would split the land. Once the auction was won, The buyer tried to back out, citing the lack of a written contract. The court held the land on constructive trust for the both of them. So, is this intervention fair? Yes, because it prevents statutory formal rules from being used as an instrument of fraud. However, it also introduces our first major critique. It bypasses statutory certainty. When the courts enforce an agreement via constructive trust under the white banner of preventing unconscionability, they begin to blur the line between contract and property law. If parties explicitly chose not to bind themselves in a formal written trust, forcing a proprietary trust upon them can step on the toes of their autonomy and create a chaotic legal mythology. The peak of judicial intervention without intention occurs in domestic disputes when an unmarried couple splits up. Historically, in cases like Burns and Burns, a partner who made a massive non-financial contribution over 19 years was left with absolutely nothing. Because, under cases like Petit and Petit, Gissing and Gissing, and Lloyd Banks and Rosset, there was no express agreement and no direct financial contribution to the purchase price. The courts realized this absolute insistence on formal intention or direct money was producing deeply unfair results. To fix this, the UK Supreme Court shifted the paradigm in joint ownership cases like Stack and Dowden and Jones and Kernet. They established that if an actual common intention to share property cannot be found or inferred from conduct, the court can impute an intention. Imputation means the court literally invents an intention that the parties never actually held, based on what the judge thinks is fair given their entire course of conduct. Imputation is fair because it allows equity to achieve individualized justice, ensuring a vulnerable partner isn't exploited. Furthermore, manufacturing intentions, the court creates massive unpredictability, suggests that returning to a strict resulting trust model might be fairer and far more certain than a fictionalized constructive trust. While imposing a trust without intention, it causes unpredictability in domestic homes. It can cause devastation. This is where the fairness of remedial trust faces its harshest test. When a court imposes a constructive trust, it creates a proprietary interest if a court uses its remedial discretion to impose a constructive trust. The claimant jumps to the front of bankruptcy, leaving ordinary unsecured creditors such as employees with absolutely nothing. Evaluating the fairness of a court-imposed trust must take into account its impact on third parties. This exact issue is currently playing out in Malaysia. Malaysian courts have shown a deep inclination toward using unconscionability to impose remedial trusts. We can see the intense struggles with third-party rights in the Malaysian banking sector. In the federal court decision of Malaysian International Trading Corporation and RHB Bank, and later in the case of CIMB Bank Berhad and Sabang Gemilang Sdn Berhad, the court had to deal directly with commercial fund flows where no trust was originally intended by the active contract parties. By treating the constructive trust as a flexible remedial device rather than applying pre-existing predictable contract, the courts create an intense commercial trepidation. What a judge sees as fair in the moment can be upend. Finally, we must look at how the courts impose constructive trust mechanism on strangers, third parties who were not part of the original trust but intermeddled with it. The court imposes liability completely independent of any intention. In the case of Baden and Society Generale, a stranger who receives a trust property in breach of trust can be liable. However, in the case of Re Montague's Settlement Trust, a party received heirlooms genuinely forgetting they were subject to a trust. The court ruled that because his conscience was not tainted by subjective knowledge, it would be unfair to hold him liable. Furthermore, in the case of Royal Brunei Airlines and Tan, the Privy Council held that the objective dishonesty is the necessary and sufficient ingredient to hold a stranger liable for assisting a breach of trust. The Malaysian courts have adopted a highly robust approach to this. In the case of Kwan Peck Seng and Robert Duran, the court carefully analysed the objective test for dishonesty for third parties' accessory liability. This was reinforced by the landmark case of CIMB Bank Berhad and Maybank Trustees Berhad, which established a combined approach. Under this, the court looks at whether the defendant was dishonest by the ordinary standards of reasonable and honest people, while also looking at the defendant's subjective knowledge of transaction. In this context, the court imposed liability is highly fair. It does not invent property rights out of thin air. Instead, it holds commercial actors accountable when their consciences are objectively compromised. To conclude, have the courts been fair in imposing constructive trust when no trusts were intended? In cases like fraud and dishonest assistance, which is reinforced by in the case of CIMB Bank and Maybank trustees, the court is completely justified. Fairness demands that equity acts as a court of conscience to strip away ill-gotten gains, regardless of what the wrongdoer intended. However, in domestic property, the fairness is deeply compromised. By utilizing imputed intention or expanding unguided remedial discretion, it is heavily critiqued in both the UK and Malaysia. The courts risk replacing stable property laws with unpredictable judicial whims. As equity continues to evolve, the judges must remember that true fairness can't be achieved if the price we pay is the complete destruction of legal certainty. This is the end of my presentation. Thank you.